Welcome to Thinking Boldly. This is the podcast series for the Concilium Institute. I'm retired Judge Julie Field, and I am here with the co-founder of the Concilium Institute, Heidi Webb. And we are very honored today to have Professor Joan Meier with us to talk about the pioneering work that she has done for families across the country and really across the world. So may I call you Joan?
Of course.
Okay, Joan, welcome, and thank you for being here with us.
Thank you so much for having me, Julie. It's great to be here.
Well, and let me just tell the world about your brilliance, because I've been able to learn much about you over the years that I've known you, but I think the world needs to know who you are and what you've accomplished. So Joan Meier is the National Family Violence Law Center Professor of Clinical Law and Director of the National Family Violence Law Center at George Washington University Law School. Professor Meier has been a clinical law professor for 34 years at GW Law School, and she has founded 3 pioneering and nationally recognized interdisciplinary domestic violence clinical programs. Joan is well known for her publications on domestic violence, child custody, social science and the law, her clinical teaching, her publications on various Supreme Court decisions, and her especially known for her 5-year empirical study, Child Custody Outcomes in Cases Involving Parental Alienation and Abuse Allegations, which was funded by the National Institute of Justice and completed in 2019. Those findings have been written about in scholarship and multiple media outlets, including the Washington Post and the New Yorker. Professor Meier founded the Domestic Violence Legal Empowerment and Appeals Project, DV-LEAP, in 2003 to provide pro bono appeals in domestic violence cases. And in August of 2019 is when Professor Meier stepped down from DV-LEAP and launched the National Family Violence Law Center at George Washington Law. This center is the only national organization specializing in both domestic violence and child abuse. It focuses on improving court responses to such cases through professional curricula and trainings, amicus briefs, and policy consultation. Joan has received numerous awards for her cutting-edge work, including the Kahn Award from the National Equal Justice Library for her article on domestic violence and welfare reform. Joan graduated magna cum laude from Harvard University in 1980 and cum laude from the University of Chicago Law School in 1983, where I first had the opportunity to meet Joan, who was a couple of years ahead of me and someone I much admired. She also clerked on the U.S. Court of Appeals for the Seventh Circuit after law school. So, Joan, thank you again so much for joining us today. We are just really excited to hear from you and your wisdom today. So thank you.
Thank you. Again, I apologize for the ridiculous length of my title, which has to do with being a research professor for a center rather than a name. Anyway, thank you for saying it all.
Oh, it's worth saying all of it because of all the work that you've done. I mean, you've done cutting edge work, and I know that you've been doing work around domestic violence and clinical teaching and approaching these issues from a different perspective and a new perspective that started back when you first started teaching, I think, 30 plus years ago. So what got you started with doing work with families and particularly in domestic violence and child protection?
It's an interesting question. When I was in law school, I think it was the end 1983, my last year, the first article came out in a mainstream national publication about domestic violence. It was the Burning Bed, the Farrah Fawcett show about the burning bed. And I had already gotten interested in this topic, and I think it was because I knew I was a feminist and I identified that way. And I'm not sure what in particular about domestic violence, but I wanted equality for women and men in families. And this thing came out, and I went up and bought 10 copies, and I got really interested in it. And my first job after law school was with Legal Services in Chicago, and it was just a summer position, and it was a fellowship, and they allowed me to work on a criminal domestic violence case. And I was the advocate. I wasn't even, barred and wasn't able to represent her, but I came in as an advocate, and I advocated for her to get a protection order, even though she was still living with the guy. And the judge yelled at all of us, "You want me to give her a protection order and she's still going to live with him? Blah, 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 blah." And that kind of, I mean, I was already very interested in the topic, but I have to say, I think that really radicalized me in the sense that, oh my God, we have a lot of work to do. So I came out of that being very interested. And I had a couple other jobs before I got into my teaching career. And all through them, I was interested in this, and I did a little bit of pro bono on the side in one position or another, different types of things. And I I think even before I got into my teaching job, I wrote my first article for the Washington Monthly, which is a very short kind of talky magazine, and it was about the history of denial of domestic violence and how all the systems deny it. And there was a very rich field to draw on for that article. So I wrote about police, prosecutors, and courts, and talked about the changes that are starting to happen. So I was already looking into that and knowing what was going on and so forth. And I thought I wanted to teach because I was the child of a professor, not a law professor, but I came from an academic family, and I thought of myself as kind of intellectual, and I wanted to be in academics, but I also really wanted to make change and do things and help clients. So I did some of that first, and then the teaching job I took, of course, was in the clinical programs, which allowed me with students to represent people in court. And so quickly, I started in a broader family law clinic, and then I created my own domestic violence clinic 1 year into it, and have been doing that work ever since. That's a short beginning, kind of.
That's amazing.
Yeah, well, I mean, it sort of explains sort of how you were, seeking to combine these things, but also really impacted by your own environment, your own experience, and how this, I think it's not unusual for people to have a really jarring early experience that is pivotal in a way that you sort of can't anticipate until it happens, and then it resonates, and then it's like, yeah, this is not okay.
So I never experienced domestic violence directly, not partner violence directly, but there was a power dynamic in my family. My father was sort of the big man on campus. My mother was not employed and was a housewife. And there were moments and times when that power dynamic was very troubling to me. And I do think I sort of grew up and grew into this need to combat that without it being about violence in my own history. But yeah.
Yeah, but you had sort of a sensitivity or sort of I don't know, a visceral knowledge of like, this doesn't feel okay.
Yeah.
Like,
Yeah.
and how do I
I
sort of
had
like
some of that.
adjust
Yeah.
for it? Yeah.
Sorry to interrupt. Yeah.
No, I think that's fascinating. And I think for people, to understand that about you, I mean, there's like, I think in most cases, there's like an academic pursuit, but there's something emotional that draws you into that academic pursuit.
Yeah. I also liked that it was so cutting edge that nobody knew about it and that I could help be the person or one of the people, very much one of a group of people trying to bring it and awaken the world to it. I liked that very much. I
Mhm,
was drawn to the idea of um, bringing something new and changing the way the system understood things.
mhm.
Yeah, and being impactful. And I'm sure that, or yeah, I am sure that you encountered obstacles in doing that. And I guess I'd be interested in knowing like what some of your earliest experiences or obstacles were that you encountered from the courts or from the field.
So the story I already told you was my first exposure to that, and I think I already knew there was some resistance in the course, and I was sort of prepared for it, but it was a pretty visceral experience. Um, and then and then when I got here, people here were trying to organize to have a coalition against domestic violence and to uh, adopt laws for protection orders and strengthen them. And we were starting to train judges or wanting to, and that was hard. It was hard to get in. And then other obstacles. I mean, the biggest obstacles have come later in my career, I would say. Actually, it was sort of easier in the early days when everything
Mhm.
was new and people kind of acknowledged that they didn't know stuff. I started feeling much more frustrated 10 or 15 years into it when we had been training and teaching and writing all about DV for many years, and the courts were supposed to know sort of the basics, and they were still acting like they knew nothing and had never heard of any of it. That got really frustrating, and that's when I started to feel like there's something deeper going on here. This isn't just about information and ignorance. This is about resistance to this particular kind of information.
So, not to jump too quickly up to 2019, but is that what sort of led you up to sort of saying we need some empirical evidence here? We need to understand this in another way to make sense of it?
Yeah, so the study that I did, the 5-year study, grew out of, again, a more sophisticated and developed understanding of problems in the system. I mean, when people think about domestic violence, they tend to think of the crime and the prosecution. Um,
Right.
Maybe they think about protection orders if they've heard of them. They rarely think about custody, child custody. And
Mhm.
nor do the courts, it turns out. So the courts think domestic violence is over there in criminal court and in protection order court. And when it shows up in family court where it's a battle between the parents over the caring for the children, the courts are very resistant to taking family violence of any kind, but especially child abuse, seriously in the custody context. They tend to think it's just, problems in the relationship. It's got nothing to do with
Mhm.
parenting by the perpetrator. So I started experiencing the problems in that around when found it a little before I founded DV Leap in 2004, because as Julie knows, we were referred a case that we helped pro bono of a
Mhm.
professional woman who was actually a lawyer, and her husband was also a lawyer, but he was also an abuser. And we helped her in the appeal, and we saw through that the depth and the complexity of the way the abuse was denied and the significance of the abuse was denied, and the way the mother was discredited for incorrect reasons and so forth and so on. We saw many layers of the denial of these issues
Mhm.
in custody court. And when I launched DV Leap right on the heels of that case, I actually said, I'm not gonna do custody, it's too draining. That case, like, ate me alive for 6 months, and I just I need to do other kinds of. I was hoping for custody criminal and protection order cases, but everything that poured into DV Leap, which was taking appeals pro bono, pretty much everything was custody. So, I'd say around then, the early 2000s was when I started turning and was kind of forced by the demand to start specializing and digging much deeper into the custody problem. So I was seeing this problem, and all these appeals were coming in where mothers weren't able to keep their kids safe from an abusive father. And I was reading transcripts. So I was, the next best thing to being there. I was seeing how the trials go because the transcript records every word that's spoken in a trial, and you have to review that if you're an appeals lawyer, because you have to know what was raised at trial and what the court said and what the witnesses said and all that stuff to analyze the potential for an appeal. So I was seeing all these cases word for word, and seeing how mothers were demeaned and treated punitively, and how abuse evidence was kept out, and how parental alienation was being used to deny the allegations of abuse and deny the credibility of the children's own words, et cetera, et cetera. I was seeing all those layers, and my first reaction was to start doing trainings, and I did a training at AFCC long before you and I met, Heidi, and I cried coming home because I hadn't realized that parental alienation was so integrated into the family court system. I thought it was
Mhm.
a pernicious theory that was being misapplied to deny abuse, and we needed to just educate courts about it. And what I realized after that conference was that no, it was fueling and driving family courts. They were very wedded to it, and I was just seeing it among the professionals. So, so I saw that in the AFCC. I was doing trainings here and there when I could, and I was doing research and scholarship, which is what I'm supposed to do as a law professor, in which I was sort of deconstructing as best I could the way parental alienation was discussed and understood, and trying to lay out
Mhm.
word for word why that understanding didn't work and was misleading and was wrong when it comes
Right.
to abuse concerns. And if I say so myself, I wrote some of my best articles doing that because they were very integrating of the social science research with
Yep.
legal thinking and with court experience. And I did these great articles, and some of them were like, a couple of them were kind of invitations to the alienation field to some extent, because they were like, here's a way we can do justice by abuse without throwing out alienation. And I actually
Mhm.
in uh, proposed a decision tree, which I said could
Hmm.
Right.
constrain the ways it's being used wrongly
Mhm.
while still allowing its consideration
Love
without
that.
using it
Yeah.
wrongly. And I sort of
Yeah.
hoped that someone in that field would take me up on that. And there was radio silence. Nobody had the slightest interest in stopping it from being misused. And that's one of the things that has been so disillusioning to me, because I like to think that lawyers and psychologists and people who work in courts and who are scholars as well care about integrity and honesty and doing, trying to meet halfway if there's a critique, like what are we doing? Maybe we could do something better. And what are you doing, Joan, that you should do better? And I was open to the conversation, but they had no interest in it. They have never had an interest in it, which started to convince me that there wasn't entirely good faith in that field, which was troubling. But anyway, so eventually, I mean, my trainings weren't working, my articles weren't working. Eventually, and the media were not interested in these stories because they thought it was the exception to the rule. They thought the norm was that mothers always win custody, and now and then mothers lose custody, and there's probably something wrong with the mother, and that's why it happened. I couldn't get them to accept it as a significant issue of public interest. So finally, I was like, we need data, because the judges aren't listening,
Mhm.
the professionals aren't listening, and the media aren't listening. We need data. And I was like, it's possible the data will show me that I'm getting all the worst cases and it's not representative of what's going on out
Right.
there. And I would love to know that if that's the case. So we put together this study. I was lucky to find people with experience with NIJ grants and people with social science research
Mhm.
expertise. And we were very lucky to be funded the first time we applied. And the goal of the study, I can go into that if you want or not, if
Yeah,
you think
no.
that's too much.
No,
Okay,
I'd
so
love to hear about that, and then circle back a little bit on whether or not you find this sort of presentation by lawyers to be, sort of commingled with issues of constitutional law and parental rights, because I think that's something that I often
Mhm.
we're
see.
seeing we're
Yeah.
seeing more
Yeah.
now. Yeah.
Yeah.
Um, I'll take that first, I guess, because it's shorter. um, I have heard for over a decade that judges felt like they have to give parental rights to fathers because it's a constitutional right. And
Right.
the person I remember who told me that, because she was doing trainings, and I was like, "That's ridiculous. The constitutional right is to be considered and to have parental rights, but it doesn't mean you have a right to time with your
Mhm.
children.
Right.
Parental rights are separate from having time with your children, and the court's job is the best interest of the child, not to make sure that each parent gets time. In fact, mothers get cut off from kids all the time, and nobody makes the constitutional argument then. So I think the parental rights claim has always been um, misstated, to put it nicely. um,
Mhm.
but
Right.
but it sounds good. I mean, there is a constitutional interest in parenting, and there is, Supreme Court case law about it. And there's one person in particular who's taken all that and kind of parlayed it into a legislative proposal that he's taking to different states and claiming it's all constitutionally mandated. And a lot of people like it, including mothers who have lost custody, are getting on the bandwagon with
Oh,
that because they don't
understandable. Yeah.
understand. Yeah, they don't quite see where it's really coming from and where it's really going, but it could help
Mhm.
them in theory. So anyway, that is out there. I just think it's completely wrong. And I have actually
Mhm.
I did write a very short rebuttal to that particular proposal for one state, which I can dig out at some point. I that was in the past year really that came up, and I did that. I didn't used to hear it that much, and I haven't heard it much in court, although it may be silently in
Mhm.
judges' heads. They're not necessarily saying it.
Mhm.
I haven't heard lawyers argue it either in court myself. But
Mhm.
I think that we're going to be seeing that more, especially as Caden's Law, which I wanna talk about Caden's Law, is, gaining traction across the country, and I've heard just within the last week, I've heard from judges in Colorado that they're concerned that the, requirement that the legislature just made in Colorado that said that the court has to make specific findings on safety has constitutional implications for parental rights under Troxel.
so yes, that's floating around there. It's gaining some traction here and there. Judges have been worrying about it here and there, and maybe more so now. I don't know. So there is that. I don't think it's the core problem, but it's just another tactic. Like alienation was a tactic, and now
Right.
this is another tactic. Um,
Well, it's that father's rights. It's raising
yes,
up
it's
that
all about
father's
father's rights,
rights.
as though they're different from
There's
mother's
no
rights.
other
You know?
or children's rights for
Yeah.
safety.
So the purpose of the study was to see whether empirically, quantitatively, we could show whether courts really are rejecting abuse claims as often as it seemed like they were, and whether they were also removing custody as often as it seemed like they were from mothers who were reporting abuse. And so what we did was and the other thing was the only studies up until that time were local and regional, because the only way to look at court cases was to go to the courthouse physically and get the files if the court would let you have the files, and sometimes they won't, and then analyze all the files. And so that's very state specific, if not even county specific, et cetera. And I was determined to get a national picture of what was going on. And by the time we started this, it was 2014. We were very lucky that courts were starting to post opinions, decisions online. And that's what allowed us to get a national picture. We were able then to gather data from across the country by state by looking at court decisions that were posted online. Now, admittedly, the court decisions don't tell you everything you might want to know, so it limited some things for us, but it gave us all the data we felt we most needed. And what we did was we looked at, did either party allege abuse? What kind of abuse? Did either party allege alienation? Was child welfare involved in the case? Uh, were there lawyers? Stuff like that. It was a very fine-tuned set of codes that we had two stalwart law graduate coders who spent over a year coding thousands of
Wow.
cases. Because what we found when we did our search for cases using Lexis, we did a very comprehensive search. We used all these different terminologies because states use different terms for domestic violence and
Mhm.
for custody as well. And all these different, so it was like an 11-line search string with all the
Mm.
different terms and all of the alternatives and such. And it netted us 15,000 cases, which we never
Oh my
expected.
gosh.
So the first 6 months was spent triaging out cases that didn't belong in the study for various reasons. They were child welfare cases, or they were cases involving someone in prison, and we didn't want to look at those, et cetera. We ended up with about 4,300 cases that were parent against parent, involving custody or visitation, and involving abuse or alienation claims. We did not collect cases that didn't involve abuse or alienation claims. So that also limited some of our numbers. But anyway, ultimately, we were able to say when moms allege partner violence, this is how often courts believe them. When they allege child sexual abuse, this is how often courts believe them. And we threw out, by the way, same sex parents because we were trying to do the gender analysis specifically. So we only looked at mother father cases. So when the father counterclaims alienation, do courts believe these things at a different rate, same rate, et cetera? And also, when mom alleges this and father alleges alienation, do moms lose custody at what rate? And when they don't cross claim alienation, is that different? So we were basically looking big picture. Do abuse allegations work, and do they lose custody when they allege abuse? And do cross claims of alienation affect those rates? And what we found was yes, 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 and yes. Um, Courts are very skeptical of abuse claims to begin with. They only believe family violence claims in general under 40% of the time, well under 40%. I don't remember the exact number, but I think it was in the 30 percentage range. If you separate it by partner violence and child abuse, courts believe partner violence 45% of the time, but they only believe child physical abuse about a third of the time, and they only believe child sexual abuse closer to 15% of the time. This is
Wow.
without alienation claims. When you bring in cross claims of alienation, all of that plummets still further. So basically, I'm gonna I'm I'm not sure I remember the crediting rates as well as I remember the custody loss rates,
Mhm.
but basically the rate of crediting falls much further when there's a cross claim of alienation, and it becomes essentially zero. We had 2% for sexual abuse. But when we went back and looked at that case, it was one case. It wasn't a sexual abuse case. So it was miscoded. So it's the right
Wow.
number for sexual abuse is 0, but we've published our 2% figure, so we sort of use it. But, uh, and
It
then
would
when
be sorry. I'm just thinking it would be interesting to look at same-sex cases, same-sex marriages, because you don't have sort of the gender disparity, but you just have the abuse and the alienation claim, if that's happening.
it would be very interesting, and I think somewhere in our
What's
data
driving
set,
it?
we probably have those cases, but it wasn't very many. I mean, because it had to be same sex plus abuse plus and/or alienate, you have to have all those
Yeah,
criteria. But
right.
Right.
yes, it would be really interesting to compare that.
Well, I just
Um,
wonder if the part of what the courts are hearing is, like, when they hear the alienation claim, does that discredit the abuse claim, regardless of gender? Or is it
no, I can answer that
I
actually. So
okay.
we were able to find enough cases where mothers accused fathers of alienation and fathers accused mothers of abuse. And we were able to find that alienation doesn't work for mothers the same way it works for fathers. And that was a statistically significant conclusion. So it confirmed what we knew about the origins of the alienation theory, which was that it was originally conceived by Gardner as a syndrome that mothers use against fathers. So it's still working that way to a fair degree. Not
Mhm.
not only because mothers are getting some mileage with alienation against abusive fathers, but
Mhm.
ironically, most of those fathers are also serious batterers. And I've seen cases where the court basically harped on the alienation, but not on the serious violence, which
Oh, interesting.
astonishes me. Yeah.
Yeah. What do you think the barrier is? What do you think the barrier is for judges and for people at large to accept the truth about what's going on in families? That's a big question, I
It
I
know.
is
mean,
big.
I always say it's overdetermined, and I have kind of a list of reasons. One of them is that courts, and I think a big one, is that courts are very devoted to trying to equalize parenting for the
Mhm,
sake of children. And there's a
mhm,
sense that children need fathers and fathers deserve children, and that grew out of the women's rights movement, and that's the part of the fathers' rights movement that was legitimate and that many of us empathize with, right? There should be equal parenting, and children should have the benefit of that when the father wants to be an equal parent, if they're safe and loving, if they're a decent parent. But there are a lot who aren't. And the courts, I think the other things that in connection with wanting to prioritize fathering, they are also coming from the place that many others are coming from, which is that they believe that they're biased towards mothers. And they're bending over backwards to not be biased towards mothers. And what I
mhm,
would say is that they're bending over and becoming biased towards fathers pretty clearly, I
mhm,
would say, at least in the abuse related cases. I can't
mhm,
speak to the non abuse cases because I haven't researched them. We do have some alienation cases where the abuse wasn't at issue, but I haven't looked at them very closely. But in the where abuse is alleged by a mother, there is a bias towards fathers, I would say, and it's partly for the reasons of trying to equalize, but it's kind of a misguided attempt. But also, th- there's ignorance about abuse and not understanding it, not understanding how partner violence has implications for children's safety and well-being and trauma, not believing child abuse because believing in the vengeful ex-wife stereotype,
right.
and being over trained and misled by alienation trainings, which train judges to believe that children can't be trusted when they report abuse,
Mhm,
that children can be misled and brainwashed by mothers into believing things that are completely false. They can even be brainwashed and alienated into being scared when there's no reason for fear. I mean, the level to which parental alienation is used to write off obvious indicia that children are terrified and just chalk it up to alienation is astonishing to me. But I think it's a product of a lot of training and scholarship that condones all of this. And there's all this scholarship backing the trainings. And courts are not in a position to go read the articles and say, like I do, this doesn't add up. They take the
right.
trainings at face value as they should be expected to. But I,
Well, and And I also think, coming from a judicial perspective, we see the hardest cases. Judges see the hardest cases, and many of those cases are cases that haven't resolved, haven't settled because it's a way of perpetuating coercive control and abuse.
That's
And
right.
so I think if depending on where you start in terms of your premise, if your expectation as a judicial officer is to say, why can't these people get along? Most people should get along in a family relationship or intimate partner relationship. There should be equal power and that kind of thing, or there's presumed to be. But then what you're actually seeing is the most extreme um, imbalance of power. And that's all you see,
And you
right,
don't
in the
recognize
courtroom.
it as an imbalance of power. You see a
Right.
lot of rage and kind of seeming craziness on the part of the victim, and you don't chalk it up to having been abused. And even if you do, some judges feel like, yeah, she was abused, but she can't possibly be a functional mother because she's too whatever, crazy,
Right.
dependent, whatever it is. Mothers
Or
who
that
are
relationship is now over, and so she'll be fine.
well, so he'll be fine because it
He'll
was
be
the
fine.
product of
Right.
the relationship.
Yeah,
Yeah,
right.
yeah.
Right.
I mean,
Yeah.
they tend to think that if the mother is even if she's messed up because of the abuse, they tend to think that messed up is gonna stay. They don't tend to think in my experience, they don't tend to think, "Oh, she'll be fine when she's out of the relationship." They think she's got psychological diagnoses and conditions and anxiety and depression and all these things that are medical, and whereas the father, well, he was abusive to her because they just couldn't get along. It was really bad relationship. He'll be okay now, because it's not a diagnosis.
Right, because
And
she triggered him or
right,
right.
right. And by the way, I think, one of the forms of gender bias that's embedded in family courts that people aren't conscious of really is the idea that women are, subject to diagnoses and men are not. Abuse is not something that we diagnose. We decide whether it's true factually. But women having reactions to abuse and struggling, we can diagnose that. And diagnoses become the weapon du jour to you know, to discredit and to undermine the competency as a parent of a
Mhm.
woman
Mhm.
when it shouldn't, because depression could be a
Right.
very rational, appropriate response to your situation. It doesn't mean you're not a good parent, but it's an easy label to throw on someone and say, "Oh, she's not a safe parent because
Mhm.
she's depressed," whatever.
Yeah.
So I'm not saying I've seen a lot of that, but I've seen a little of that.
Yeah. Yeah.
So I think there's a desire to increase fathering and support fathering and reward fathers who come to court because there's a belief that fathers don't fight to parent and those that do should be rewarded. There's ignorance about abuse, so they don't understand that's what they're seeing a lot of the time. There's real problems recognizing child abuse because they're taught not to trust what children say, and children can't always testify or don't always. And getting, the GALs are not always very well educated on this either, the people who are speaking for children. Um, what else? I don't know. I feel like I have other reasons, but they're escaping me right now.
So the
But those
lawyers
are
Yeah.
the
aren't
dominant ones.
necessarily equipped. The lawyers who are
Oh,
representing
yeah, that's a
the
really good one.
women aren't necessarily well equipped to understand this either.
Absolutely.
So, and I think there's an element of, yeah, may not say it in court, but sort of a resignation that your client may be ill-equipped to parent or maybe not really, fully
Well,
capable,
a
you know?
recognition or a belief that is based on also not understanding abuse. I mean, a lot of lawyers don't
Right.
believe sexual abuse when their clients tell them about it, child sexual abuse. Like, there are lawyers who won't take those cases. There are evaluators who won't assess those cases. There are people who just like run screaming from sexual abuse claims and mistrust them deeply. And so if you have a lawyer like that and you're trying to say, my kid is telling me this and doing that, and I can only conclude that he's being abused, those lawyers, a lot of those lawyers are just like, "Well, we'll just downplay that. I don't trust my client." They're not gonna tell him, but they're not gonna trust him because she's saying that. So, yeah, there are problems in the field, and then even if you do trust them, there are a lot of lawyers who don't know what they're up against in these cases and how hard they are to
Mhm.
persuade courts of, in the face of the
Also, there's a
alienation.
level I think there's just a level of discomfort too with
Mhm.
people who just hear that information and don't for themselves know what to do with it.
Right.
So
No
there's sort of
question.
like a
Yeah.
reluctance to really engage with it in a
No
way that's
question.
helpful.
Absolutely, and that, if you're a lawyer, that I would say is malpractice. If that's the case, you need to get off the case and find them a lawyer who can handle that. And the
Mhm.
same with evaluators. I've heard of an evaluator who had an 8-year-old girl telling him about sexual abuse, and he called up someone I know who's an expert, and he said, "What should I do?" And she told him how to talk to her about it. And did he do that? No, he shut down the conversation. And I'm
Mm.
like, that's malpractice as an evaluator, in my opinion.
Yeah.
So,
Yeah.
because he was too uncomfortable. Don't be in family court if you're too uncomfortable with abuse, all kinds.
So what it's a huge problem, right? Multi-layered, faceted problem that exists throughout the profession and the courts. What advice, if you could say 1 or 2 or 3 things that lawyers should do differently or judges should do differently to, not fall into this, abyss of, not protecting children and not protecting victims or survivors of domestic violence?
So, most of those things we put into Caden's Law, not all of them.
Mhm,
Before I get to Caden's Law, let me say one thing. Every lawyer and every client that contacts me and says, "This is my story and I'm fighting for my kid in family court," I tell them they have to have an expert. Especially if it's child abuse. If it's partner violence, you might be able to prove the facts straight up. If it's child abuse, you've got to have an expert to validate the child abuse because courts are just too reluctant to take it from you as a reporter of what your child's saying or doing. And an expert, especially a child forensic interviewer, which is a particular high level of
mhm,
training to do a proper kind of child interview that doesn't taint the interview with bias. Those interviews, if they're done well, are the best source, I think, of validation of a child's report of abuse. So, for lawyers and protective parents, I would say make sure you can do your best if you can possibly do it to get an expert in that kind of abuse that you're fighting over. And there aren't that many, and they cost money, but I try to get them linked up. For lawyers, I've done a lot of trainings for lawyers in these kinds of cases.
mhm,
One of the things we try to train them on is to be able to cross-examine the alienation expert. They have to learn enough about what's wrong with the alienation theory and how there is no science behind it, and how many of the common claims that are made by alienation people, are not supported scientifically. My newest article, which is waiting to be published, it's as part of a special issue, and there's other articles are slower than mine was, and so it's waiting to be published. But it's called "Misinformation about Parental Alienation Misleads Courts and Endangers Children," and it focuses on two very common claims by parental evaluation experts or evaluators. And one of them is that children who are enraged at a parent aren't abused, they're alienated, because the theory is that abused children don't get mad at their parents. They really want to be reunited with their parents. Where does that come from? Foster care research, which A has no bearing on research on how children feel when they're living with a safe parent and have no need to go be with an unsafe parent. A, and B, those studies did not actually reach that conclusion to that degree at all. They're being in my article, I collect the research into domestic violence and child abuse that describes how angry children can be at their abusers.
mhm,
But
mhm,
anyway, the other claim is a little less absurd, but is problematic, which is that parental alienation has such lifelong damage to the person who grows up having been alienated that it's as bad or worse than abuse, direct abuse. And that claim is pure assertion in my view, but it's when they cite something for it, which they don't always. They cite articles by the same researcher who did the other stuff, the foster care research, which wasn't bad, by the way. The research itself wasn't bad, but this research isn't very good because it's interviews with adults who say they were alienated as children against one parent, and now they have this litany of struggles as an adult. They have a drinking problem, they're depressed, they can't date. And guess what? In many of those cases, there was also abuse in the family. But the studies cannot parse out how much different things going on in the family affected the adults, and the adults don't know. They can't know, but they're only being asked a set of questions about alienation. And that's the data that's being used to prove and claim that alienation has such lifelong severe damage that, it's as bad or worse than abuse. So this article deconstructs the research and shows how absurd it is. And it quotes from real evaluations to show how these things are being misused. So I'm hoping it will be useful for lawyers. This is the connection back for lawyers to use with cross examination,
Mhm.
because I can't expect lawyers to go in and do all the research I'm doing about the limits of the research. So I'm trying to convey it to them here and allow them to do that. And if judges will read my article, they will also know that, even if the lawyer doesn't. So they can start questioning also those claims. So that's one thing, is everybody needs to learn enough about the limits of alienation and how it's being distorted as a theory and misused to deny abuse. Um, Another thing is you've got to have an affirmative expert to validate child abuse, because courts they're very reluctant to validate, to believe it. They feel like it's gonna Here's another reason, Julie, that it's hard for courts. They feel like it's gonna tar the perpetrator forever and that he might get put in jail if they find that he sexually abused or physically abused his child. In reality, I don't think so. I don't think prosecutors are looking at family courts and finding out which ones found anything. And usually those cases have already been declined for prosecution or are often likely to, because the burden of proof is so different. But I think judges are very hesitant to potentially put a criminal finger on the scale against a parent. And so they're reluctant about child abuse. And so
Well, I think
ex
there sorry, go ahead.
well, I was gonna say experts can really help with that and explain the validity. What were you gonna say,
I
Heidi?
was just gonna say I've seen some reluctance on the part of lawyers to present that evidence in a family law case because they think judges, sort of for all the reasons you're saying, like, these are courts of, you know, sort of not reconciliation exactly, but we're trying to engender a family moving forward, and it sort of tarnishes
Mhm.
the family if you bring in testimony, and again, that works against the person who is bringing in the evidence because it looks like you're trying to build a case,
Demonize.
and
Yeah,
yeah, to demonize
demonize the
somebody.
other parent. Yep.
Right, and
And the problem is it wouldn't be in court if this family could work together and do what's best for the kids. And it's
Mhm.
in court because they can't. And when someone alleges abuse, that should be logical to you if you're in family court, because yeah, these are the 6% of cases, is it, or 8% of cases that actually go to trial
Right.
out of all the families that separate and divorce.
Mhm.
So it is, I agree that the culture of the court, and especially traditional family lawyers, those who represent men in particular, but the traditional family lawyers want to settle out of court. They don't want to try cases, and the last thing they want to do is sound like they're firebrands bringing in, you know,
right.
little nuclear bombs called child sexual abuse.
Well, I think it's a strange dichotomy that so few of the cases so few cases go to trial, in family law, but the ones that do and have this issue, there's this almost, I don't know if it's subconscious, conscious, but this desire to treat them like a quote unquote sort of normal, to normalize the
Right,
situation. But
right.
they're there because they haven't been able to normalize the situation. It's sort of
Well,
like they're
yeah,
outliers just by virtue of having gotten to that point.
and sadly, family violence is really quite common. We don't want to believe that, but it is. And I one of the things I'd like to do is find a way to help educate judges about that. That it is really common, that you shouldn't be surprised when you see it in your case for the reasons you're saying, Heidi. And, um, you know, this is about children. We have to protect
Mhm.
children. And you're not criminally convicting anybody, and you're not penalizing anybody. You're taking care of children's well-being.
Right.
That's all you're
But
doing.
I think when these same sort of issues arise in the, say, district court on a child abuse claim, like child protection, they're believed, they're heard, and I would think in a way that's different
Right.
than in family court
Because
because it's
because
usually
Because the
not a
state's
family
involved.
member.
because the
Right.
state is saying it, not the mom. And
Right. The
Right.
state is saying it,
moms are not
exactly. The state,
credible. Right.
and a
Right.
lot of times it's sort of like a, adjacent member of the family or something. It's not a parent.
Mhm.
Right, an
Sometimes it
uncle
is,
or
but
somebody.
sometimes an
Yeah,
uncle or grandfather,
yeah,
like whatever, but
or stepfather.
neighbor.
Yeah,
Mhm.
Yeah.
yeah.
So Caden's Law. Tell us about Caden's Law, what
Okay,
it is, where it came
so
from.
so Caden's Law was named after a little girl who I think was 8, who was murdered brutally by her father during a court-ordered visitation. She had been taught to run for the door if she got scared, and her body was found right at the door. And sorry, her mother, felt like, "I can't let this happen to anyone else," which is typical for traumatized people. When something could have been prevented, they often turn into warriors to prevent it happening. Same with gun violence and other things. And so she connected with my colleague, Danielle Pollock, who at the time was not my colleague, but they were both in Pennsylvania. And Danielle was doing legislative work and other work with another group, Child USA. And they started working on developing a statute to try to protect future kids. Danielle brought me in, and she also brought in Richard Ducote, who's a kind of a godfather of this field,
Mhm.
who's been a very, very powerful advocate for protecting these kids in these cases, and has even argued one in the Supreme Court long, long ago. And the three of us, and then with the help of some other colleagues and some legislative experts, pro bono lawyers from firms, we we drafted a law that we thought would help courts do better. And it went through many iterations, so I'm going to leave out the ones that ultimately got chopped when it was on the Hill. It ultimately was picked up by Representative Brian Fitzpatrick from Pennsylvania, who saw what Danielle was doing for the state legislature, and he said, "We need something federal." And so we said, "Great, let's do this, and you can roll it into VAWA, the Violence Against Women Act, as an incentive law, because the federal government cannot regulate and govern state courts on custody, but it can create incentives for states and state courts." So Caden's Law boiled down to 4 provisions, and it did get rolled into the Violence Against Women Act as an incentive law. Um, the first provision is that you have to hear all evidence presented, if it's admissible evidence of abuse, past violence, including evidence from before the last hearing, et cetera, et cetera. Because all of it, even if it's been previously heard or decided in a protection order or something like that, all of it is relevant to a child's best interests, even though it was adjudicated in some other context in some other way. You have to know the history of abuse to determine child's best interests. So that includes police reports and protection orders and any other form of evidence of past abuse. Second one, which has gotten so much pushback, is that we didn't e- ever think about ruling out parental alienation claims because we knew how wedded the courts and the professionals are to that. So what we said, and frankly, it happens. We know it happens. What we wanted to rule out was the misuse of it to deny
Mhm.
abuse, which is what my original article always said. And so what we said was, if you're going to have an expert assessing or opining about abuse, whether it's sexual abuse, physical abuse, or partner violence, that expert needs to have expertise in that kind of abuse. And we said purely forensic expertise doesn't count. So you had to have out of court expertise, meaning you had to have worked with victims, basically. And that has the effect of excluding a lot of alienation professionals who like to consider themselves also abuse experts, but they're not, because they've never worked with abuse victims and they don't really know the abuse field the way abuse experts do. And they're very good at denying the credibility of abuse because the way they've gotten into abuse has been in the context of alienation and doing evaluations, and not in the context of working with survivors. And so we defined experts who are going to opine on abuse as being people who have worked with survivors. I don't know if we said worked with survivors, but we basically said non-forensic experience in the
Mhm.
field. Um, so the alienation people are coming in with guns blazing at all the state. They're trying to do it more and more. They were slow on the uptake, but now they're getting more energized and activated. And where states are considering Caden's Law, which a number of states have done and are continuing to do, because children are being murdered in so many states after family courts didn't protect them. People are coming in and saying, this is going to exclude alienation. This is going to do all of these things. It's going to be terrible for children. And that's not true, because nothing in the statute excludes alienation claims. You can
Mhm.
testify about it, you can opine about it, you can evaluate it. What you cannot
Right.
do is opine about the abuse if you're not an abuse expert. I think that's a very fair compromise that allows
Mhm.
for alienation discussions and assessments while trying to ensure that abuse assessments are clean and are valid and not
Right.
tainted by an alienation commitment.
Right.
So
Right.
that's what it says, but they're distorting that in these battles. The third provision is about reunification remedies. And that is something that there's been a lot of press about because a lot of kids are now old enough to talk to the media about what they went through. But basically, the alienation field has designed these treatment programs, some of which are called camps, many of which are overnight and far away from wherever the child lives, and they cut the child off from anything that from their life and make them go with the alienation treatment people and the parent they're resistant to. And then they're forced into contact and they're sort of hammered with videos and didactics about how everything they thought about their parent is wrong, that the parent they love was misleading them and mistreating them, that they have to renounce everything they ever said or thought about the other parent, because if they don't, they will never see the beloved parent again. It's a very coercive and abusive intervention, and courts don't know that. They are
Mhm.
given a presentation about how these treatment programs are excellent and 90% of them work. The children are reunified with the parent they've been resisting. They don't say anything, by the way, about how often they're reunified with the parent they were ripped away from. And many of these programs will not allow the protective parent contact with the children until the protective parent says to the satisfaction of the person running the program that everything they said was a lie and false, and tells the children that. And if a protective parent can't do that, or even if they try to do it but it's not convincing enough, they never get to see their kids again. And kids are stuck with a parent they resisted, often for good reason, but the court didn't believe that. These are the kids who are getting murdered. Well, some of them are murdered during visitations, some of them not. So so the reunification provision says basically you can't rip a child from a parent they are attached to and bonded with who is non-abusive. And we
Mhm.
say physically or sexually abusive because we know that the alienation professionals are now saying that that is psychological abuse. And we
Right.
knew if we said psychologically abusive, they would just shoehorn alienation right in there and take the kids away. So we said physical or sexual abuse. If that's not there, you don't get to rip the child away. Whatever reunification treatment you do, they get to stay with their safe parent in the meantime. And there are treatments that don't require you removing them. And then we say that there needs to be proof of safety and effectiveness of the treatment program, which has been very controversial. And we are working on how to rephrase that because some of our friends have pointed out to us that there's really no proof of safety and effectiveness of any kind of therapy, including therapy for DV survivors or, maybe cognitive behavioral therapy may have
Yeah, I was gonna
that
say
proof.
CBT probably
Yeah,
does have some.
but most traditional therapies that people go to for emotional difficulties don't have that kind of proof. And so we were thinking, yeah, we need to try to figure out how to revise that, and we haven't entirely. But the
Mhm.
states that are adopting this law are all adapting it and tweaking it in different ways. And they're naming it
Right.
after the kids in their state that have either been murdered or suffered
Mhm.
in one of these cases. And there's been some really interesting additions and improvements to Cadence law that we've seen in different states that we think should be carried forward. So that's the third provision, and the fourth provision is training. It requires it requires states to provide that training on a series of abuse-related topics like coercive control, child sexual abuse, child physical abuse, and psychological abuse, um, bias, implicit bias, how perpetrators and survivors appear in court, like sort of
Mhm.
the dynamics
Mhm.
of that. There's a series of other topics that I'm forgetting now, but it lists topics because these were the things we felt courts don't get in a normal course of trainings. And these are the things
Mhm.
that are undermining their ability to properly assess abuse claims. So
Right.
those are in there. And I'm very pleased and proud to say that my National Family Violence Law Center, which started some years ago on developing trainings to meet those requirements, has now completed coercive control, which is a 3-hour training, and child sexual abuse, which is 3.5. They're both online on demand,
Oh,
and
wow.
they're interactive. So, and
Oh,
they're very,
great.
very reasonably
That's
priced.
fantastic.
Yes, Julie, you should know that. I will send it to you right away. But
Yes,
we're trying to
please
get it
do.
out to all the courts, and actually finally
Mhm.
dawned on me this year to mail it, to get all the addresses and mail it, and that started having an effect. So I'm hearing from more courts now that are buying it, and the
Yeah.
judges are really liking it.
That's
And so word
great.
of mouth, they're telling their friends to take it, and the
Oh, good.
evaluations are
Yeah.
very favorable. Like
That's terrific.
96% of people, including judges and others, are saying other judges should take it, other evaluators should take it, and
That's great.
I recommend it to them. So, um, it's a wonderful course because we're drawing on all the experts. I'm not the expert, but I know who the experts are on all of these things, and so they're in there. There are clips of them, and it's doesn't have me in it at all, and it's done by educational design experts who are really good at it, and it's framed in ways that I think judges can take in as information rather than feeling like
Oh, that's fantastic.
that it's not
That's
like an
rich.
advocate hammering at them. So,
Sure. No, that's terrific.
yeah.
Um, how many states have adopted versions of kid law?
So I always ask Danielle to update me, but I think the last I heard, 10 states have adopted some parts of it. 2 states have adopted all of it. Um, it's interesting the different parts that different states have adopted. Like 1 or 2 states just
Mhm.
adopted the reunification provision, which is surprising to me because it's one
Hmm.
of the more challenging
r-
ones for courts.
Right.
Yeah.
1 or 2 states just adopted the training for judges, but not for evaluators, or evaluators, but not for judges. And the training provision says
Mhm.
everybody, all the neutrals have to get it. Some of them have adopted the expert provisions, and some of them have tweaked the expert provisions. So it's variable. And frankly, to be honest, the incentive provision isn't working that well because the federal government getting money out of them under this law, even before the
Right.
2024 and 5,
Mhm.
we weren't doing a good job of that because the Congress didn't follow it up in the way that they needed to apparently, and we didn't know. And
Right.
now it seems like probably a lost cause. But states are doing it anyway because they're
Mhm.
seeing that they have constituents who are coming to them telling them horror stories, and they're taking it very seriously,
Yeah, and
including
Colorado, I
Colorado.
think, Colorado's been one of the leaders,
Absolutely.
in addressing first of all, in defining domestic violence and coercive control in its
Yeah.
custody statutes, 20 years ago when I first started practicing here, and, developing and adopting the Cadence Law pieces, and one of the things that Colorado just did this legislative session was to take the different pieces of Cadence Law that hadn't yet been included in the 2023 iteration of the law and making sure that there's clarity around coercive control, domestic violence, and the expertise that's necessary because there was some a lack of clarity around that in terms of what experts
The the
who
I
they could be.
the provision that
Yeah.
seemed to say that judges should send it out to the
Yes, to the
DVOMB. Yeah,
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 to the DVOMB. It
that
was
was
very,
problematic.
very confusing and problematic.
Yeah,
But the other piece of it that I think is particularly interesting is that the legislature looked not just at the Cadence Law requirements with this latest update, but also the National Council of Juvenile and Family Court Judges model
model code.
code.
Yeah. My coercive control training builds on that. It uses the model code's definition of coercive control, and it uses that, and it points out that whether or not it's in your statute, it all goes to the best interest of the child. And you still have to consider it because it affects the best interest of children. And the model code, I'm here, you heard it here, is stronger than Cadence Law. And it's kind of ironic because the family court professionals who hate Cadence Law have said not one word about the model code because it was
In-
put out by the National Council of Juvenile and Family Court Judges, which is as neutral a body as you can get. Um, and guess what? It's stronger than Cadence Law. It goes much further
Well,
in a lot of
and
ways.
the other piece of that is the National Council for many, many years has put out guidelines for judges. So even if you didn't have it in your statute, they had guidelines for judges in custody cases. So, well, Joan Meier, Professor Meier, thank you so much for taking so much time this afternoon to help us do a deep dive into some of the most challenging issues that all families face, and certainly family courts and attorneys face in these cases. And we are just so grateful for all the work that you've done and the commitment that you've had for 30 odd years doing this. Um, I can't wait to see what you do next. We'd love to have you back. As I said, after your article is published, and we could also do some kind of promotional piece for your conference in the next 18 months. So,
Well, thank you. Really, it's been an enormous pleasure to have this conversation. I was so looking forward to it. So, thank you, thank you.